time enjoining further, a further filing won't act as a stay, won't impose a stay, and won't prevent you from proceeding with foreclosure or eviction. But if you want the in rem relief, you need to go move under 105, sort of following the roadmap and the decision order that I did at docket number 67. But if all you want is an order confirming that this property is not property of the estate and is therefore not subject to the automatic stay, then you can have that order as well. But that doesn't have obviously any the sort of injunctive effect I think you're looking for going forward.
Judge, I understand everything you're saying. May I speak?
Yes.
Okay. The reason I need the adversarial proceeding is to deal with the issues of standing that I've been trying to get resolved, which are still not resolved. They never served. Additionally, they never served the trust, the estate properly, and they did what they did when after my husband, after whatever happened with all this stuff. But the thing with Robinson is that there was a stay in place from the Supreme Court when this property was sold. It was stayed. I had an attorney then, and we filed everything in the appeals court, and there was a stay. So they went and did this even though there was a stay. And I mean, I have a copy of that order if you want it. So this thing should never have been done. It should have been reversed, and whatever has to be done. It's not a situation that's cut and dry like they're presenting, especially with the stay that was in place, especially with all the other stuff. That's a problem.
Right. What from my perspective though, on the narrow issue that is presented to me by this motion, it actually is, in my view, straightforward. The title to the property is not in your name. Title to this particular property is not in your name. So therefore,
but it shouldn't be in their name.
Let me finish. So as of this moment, it's not in your name, and is therefore not property of the bankrupt estate and not subject to the automatic stay. That's not to say that there's an argument that you're presenting that it should not be in their name and should be in your name because there was a problem with the foreclosure sale. That's a separate issue. But what's before me today is, does the automatic stay cover that piece of property? And the undisputed evidence before me is that it doesn't, because it's not, at least as of this moment.
Well, excuse me, Your Honor, but to give them leave to continue when they did the sale when there was a stay from the Supreme Court, which would need to be reversed and take it out of their name. Anything that they did, anything that they filed like that would have to be vetted, has to be gotten rid of because they violated this. Yeah. Go ahead. Okay, so I need to just give this to the court. Do you have it?
Well, if it's something you want to file, then you take it to the clerk's office and have them. They'll file you up for something.
Well, I just want to give it in my defense because I'm telling you something. Here's the evidence.
No, right. What I'm saying though is, if you want to bring a motion asking me to impose an injunction, yes, that is your right, subject to the procedures and rules and standards that govern that. The question before me is this property covered by the automatic stay, the automatic bankruptcy stay? And because it is not in your name, it is not covered by the bankruptcy stay.
Okay, well,
the automatic stay. So
right, this was in the Supreme Court, the Appellate Division, the Third Judicial District. It's case number 525290. Okay, and what it says is ordered that the motion is granted. Brief respondent shall be filed, served on September 25th, and this was entered, and then there was we did all that. So this was entered for the stay. Okay, it was entered August 25th, 2017. And we sent the other paperwork, all the paperwork that he needed, the notice of appeal and everything. So I understand where we're trying to stay in this narrow thing, But honestly, there's this bigger thing which obviates what they're saying. It's an untruth. And for the court to tell me that they're going to proceed with an obvious untruth in front of them, whatever they think, it never should have been done. It never should have been sold,
Right.
because there was a stay in place. And for the court to continue to say that it's fine to just deal with this small thing when we've got an obvious big problem.
Right.
Okay, because people do that. Anybody can say whatever they want to say, and they ignore the truth, they ignore the facts, and they say we're just going to deal with this. And when you deal with this, well, yeah, maybe that works, but it doesn't work in the whole picture. And I'm not a lawyer, but honestly, this reasoning makes no sense to me.
So
Sir.
I am in sympathy with the idea that, look, we're missing the forest for the trees, but the only way sort of we work as a court is to deal with trees, is to deal with individual, discrete. I have a motion before me that asks me to determine whether a particular section of the law applies or does not apply, and then that's what I need. That's what I do in individual cases that are cases and controversies before me, and I don't have a sort of roving ability to sort of try to figure out what is just in sort of a cosmic sense. I need to decide cases, the issues that come before me.
Yes, and I'm bringing this before you.
Right.
I'm bringing this before you right now.
A lift stay motion. It is an attack on the validity of a state court foreclosure.
And when did they bring this up to you, sir? How? Not in their.
No, I don't. Well, that's why I don't think
in their proceedings.
You're not disputing that this property was sold at a foreclosure sale. You're disputing the validity of the sale, but you're not disputing the fact of the sale.
But also underneath the fraud, underneath which the whole case is based on fraud. No, I am disputing the entire thing. That's why
the validity of the sale, not the fact that the sale took place.
No, the sale is not valid. If there's a stay, the sale is not valid.
Right.
And anything else, any judgments are based on fraud, vitiates those judgments.
Okay.
So all of that it's all sitting on a sandbar, with the water going back and forth. So, right, that's what's doing, and that's how it's being presented to me. And I understand you're all on the same team, and I'm not. I'm trying to get myself together here.
Now, but I take significant offense to this. There's no team here. Again, as I said, you might not agree with the way the system is set up or the way that I view the system, but I'm trying to do what I think to be the appropriate thing, no matter what party it advantages or disadvantages. That's what part of the job is.
Then then in view of all of this, I would need time and adjournment to respond to whatever it is you're seeing based on their movement to relieve the stay that they filed already.
Yes.
That's
so
fitting.
Let me ask you, Ms. Arnold, and you can say you want more time. Are you looking for just an order confirming the absence of the stay, or do you want to seek relief under some sort of injunctive relief under 105, like was granted to Celine, or do you want time to think about it? And any answer you give that's up to you.
I think we would want the prospective relief,
okay,
similar to what was brought by Celine.
Right. So what I'm going to do then is I'm going to adjourn this motion to February 26th. Ms. Arnold, if you want that relief, file a supplemental submission in further support of that and requesting that relief. And again, take a look at the decision at docket 67. Please do that by February 12th. And then Ms. Baelish, please file any response you want either to that or to the motion more broadly by February 20th. Okay?
Right.
We'll be back here on the 26th.
Okay, and this is just dealing with the relief from stay, or
this is
and what about the adversarial proceeding? Because they're going to answer something on the 13th, supposedly.
Then if they file an answer on the 13th, then we'll set it down for a status conference regarding the adversary.
because I'm going to have to be able to respond to that too.
Yes.
I may have to,
Well,
obviously.
if they bring a motion to dismiss the adversary, you'll have that'll be noticed for a hearing, and you'll have an opportunity to respond to a motion to dismiss. If they file an answer, the court will issue a order setting a status conference, and we'll talk through what the
Right, because what I obviously with the deficiencies you had a problem with I had to redo the other adversarial proceeding.
Okay.
Which I have to turn in today.
Okay.
So it was done in the same way because I thought that things get resolved in discovery, but apparently I have to put more up front than I thought I had to do, so I didn't present it properly. So I'm going to have to do the same thing.
Okay.
With that.
All right.
So
and then if you want to file you want to provide me with the document you were referencing here.
Yes.
On the 20th, when you file your statement of supplemental opposition to the motion for relief from stay, you can attach that as an exhibit to it.
Okay, so that has to be done on the 20th.
By the 20th.
So they're sending by the 12th.
12th, and then you'll be.
And then I respond on the 20th.
And then we'll be back here on the 26th.
Okay. Right. And if I need to amend my stay,
your complaint.
AP,
yes, if you want to move to amend the complaint, you have the right to do that, but you need to attach to the motion a copy of the proposed amended complaint. Because one of the things that I need to decide whether, whether to grant you that relief, is whether the amended complaint would state a claim.
Right. And the thing I would need an injunction as well, so that the adversarial proceeding can continue and this could get resolved, and not have to try to fight what's going on at the property when I've got this thing over here trying to resolve it. This is what's very upsetting about this situation, because instead of dealing with what the facts are and dealing with what I'm asking for, they're just pushing to say, okay, it's not covered. And honestly, it's not in good faith, sir. I understand. I'm not saying anything about you. I understand you've got your restrictions and things like that, but in the scope of things, like, to provide justice and things like that. And I'm not an attorney, but it should make sense to me. To me.
Well, okay, but if you want an injunction, you'll
Yes.
need to move for the injunction.
Yes.
Because there's the automatic stay, which is an injunction that arises automatically, hence the name automatic stay,
Yes.
upon the filing of a bankruptcy case that protects property of the bankruptcy estate and protects you as the debtor in bankruptcy.
Yes.
If there is property that, and again, whether it should or shouldn't be, it is outside of your name, that's not covered by the automatic stay. That doesn't mean that you can't get an injunction protecting your interest in that property, but to do that, you would need to bring a separate motion requesting that, because it would not arise automatically, because it's not, at this point,
I understand.
Okay?
I understand.
Thank you.
Okay. Thank you, sir.
Thank you, Ms. Arnold.
Thank you, Your Honor.
Oh, thank you. So I'm going to close the 105 and restore the lift stay motion to the calendar and set it for a hearing on February 26th with the supplemental briefing schedule as set forth by the court. Thank you.